Right, needed my voice to be recorded. Good morning. It is my pleasure to introduce our guest speaker today, Jennifer Stebbing. She is the owner of Stebbing Butcher PC, and she is a certified specialist in estates and trust laws. I love listening to this resume. She is one of fewer than 35 lawyers in Ontario to hold this Law Society of Ontario designation and the only one in Brantford and surrounding areas. No other lawyer in Ontario holds this specialist designation combined with 3 degrees. She also holds a BA from Windsor in International Relations. Jennifer's experience and education are unmatched, and she is uniquely qualified to help you with the simplest to the most complex estate planning and administration issues in Ontario. Welcome, Jennifer.
Thank you very much, Betty, for that wonderful introduction. If anyone guesses, I do like to go to school and take courses and all of that. So I'm going to be talking about wills and estate planning today. I had a prior presentation months ago in which I discussed powers of attorney, so I won't be touching those issues on today's session. So my little bit of intro, my disclaimer. What I'm giving today is just intended as general information. It's not intended as legal advice. I'm not intending to create a lawyer-client relationship here. And there's no confidentiality between you and me because we're in a group setting. I am going to take questions at the end. I will remind you of the same thing at the end. But remember, you're in a group setting, so don't divulge anything you wouldn't want the public to know. You're welcome to say I have a friend who instead of saying I if you want to, if that makes it easier for you. And please do wait to start the questions once we stop the recording. So about me, yes, I'm a partner at Stebbing Butcher PC. I have the certified specialist from the Law Society. I also have my Canadian law degree. I have an American law degree. I have a master's of law and tax. I'm on the Estate Planners Council, and I also have my TEP, which is Society of Trust and Estate Planners, which is an international designation. So I've really spent about 15 years now of my law career specializing in this area of estates and trusts. My firm does a little bit of real estate and corporate law as well that kind of goes hand in hand with that. So let's get right into it. So estate planning. Lots of people know the word, know what it's about, but they're not necessarily sure about what everything entails in that. So it's more than just completing your will. The will is like it's the end goal. That's what you're going to have at the end of the process. But the process looks at all of your income and your assets and what you think you want to do. And is there anything during your life planning you want to do? Is it all end of life planning? So after you pass, we can look at tax implications of how your assets are held. We can also plan for like funeral, burial, cremation, where you want to be, what kind of service you want, all of those kinds of things. We look at wealth transfer considerations. So sometimes that's during your lifetime and using trusts, or it's after and we can still use trusts. It also looks at your family situation. It's becoming extremely common to have blended families and how we deal with that with estate planning and what the intentions of the parents are for the children. We can also help you deal with international beneficiaries and assets. And then, of course, there could be charitable bequests that we deal with. So donating to a charity and how that can affect your estate plan and the potential income tax savings. So wills, I'm going to go over what they are, why you should do it, how you create one, and what happens if you die without one. So at least you know the repercussions of not taking care of this. So a will is a written document. Here in Ontario, it still has to be on paper. Out in British Columbia, they have made an amendment shortly after COVID where there is a way to do a virtual will, but it's still written in the sense that like it exists digitally written. There's no way to do like a verbal will, like do a recording or something like that. It appoints the executor or estate trustee. Those two words are interchangeable. It means the same thing. And that's just the person in charge of your estate to do what it says in your will. The will provides for the payment of your debts, because we always got to pay those first. It can set out specific gifts or legacy. So if you wanted to leave someone $10,000, it sets out who receives what portion of the estate. So we call that the residue. It's also like the leftover. So after you've paid all of your debts, you've made any of your specific gifts, who receives what's left? Do you do that in percentages or in fixed amounts and the leftover? So you can set all of that up. The will can also set up a trust for minors or other persons. So in Ontario, you really don't want someone to name someone under 18 to inherit more than $10,000 to $40,000 just because of the rules in Ontario. So in Ontario, we have something called the Office of the Children's Lawyer. They are actually, by statute, the only people that can manage funds for minors, unless it's under 40,000, and the Office of the Children's Lawyer gives permission to the parent to manage that for them. And then at 18, they get those funds. But if you set up a trust, you can say, well, the money is set aside for them, this person's in charge, they manage the funds until the age we pick. And it can be used for these reasons. So usually it's like education and betterment of life and things like that. And I usually recommend to clients that age 25 is kind of the youngest age you should pick, just when we're looking at the average maturity of an adolescent these days. But if the child's already 18 or 19 when you're drafting your will and they've got their head on straight and they're good with finances, then you can obviously make a different decision on that. Trust for other persons. So if someone's not a minor, one reason we do those is if anyone's on ODSP, that's the Ontario Disability Support Program. So ODSP only lets you have about 40,000 worth of assets accumulated, and it doesn't let you receive more than $10,000 in 12 months. So if you get an inheritance and you're on ODSP, they're going to cut you off from ODSP at that time until you then go within their requirements. There are exempt assets. That's a whole other discussion. But if someone's on ODSP, in your will, you can create something called a Henson Trust. And then that protects them on ODSP. So they can stay on ODSP. Their inheritance can be put in that Henson Trust. And then the money coming out of that Henson Trust will just abide by the ODSP rules. So currently, as of today, no more than $10,000 in 12 months. And then there's exempt payments that they can make as well. So that's another great reason to put those kind of trusts in your will. And then there's, I guess, regular trusts. So those are for people that you just either want to protect them or protect them from someone else, or you want to control where the remaining funds go after that person dies. So we sometimes see this in situations where the estate is quite large. So there's millions of dollars passing on, and the parents want to make sure that those funds stay for the benefit of their child, and then whatever's not used goes to that child's children, so their grandchildren. So they want to see that legacy continue through the generations. Sometimes people do it because they're concerned about their child's spouse, and they want to protect the inheritance from that spouse. And then others just, the person's perfectly capable of managing their affairs, but they disagree with how they manage it, or they don't think they're that great with money or something like that. And then they can put it in trust to be able to protect them from themselves. You can also state any funeral or burial wishes that you have in your will. So typically in my office, if you've already got like a plot somewhere, I refer to that in the will so everyone knows where it is and they know where you're supposed to be. If you've prepaid with a funeral home, we put that information in there as well. And I keep a copy in my file just in case no one can find it, then at least we have it and they don't end up paying for something that's already been paid for. It's also possible to refer to another document where you've written what you want to have happen if you don't want to like put in the will a very explicit instructions of like, I want a service at this church, I want this hymn, I want this reading and things like that. We don't have to put that in the will document itself. We can refer to it as a schedule, and then you can put that with it. So you have a lot of freedom there to be able to make sure that the people who are left behind can do what you wanted, the way that you wanted it, where you wanted it, when you wanted it, and all of that. So how do you create a will? As I mentioned, it has to be in writing. And there's two different ways it can be in writing. So if it's written in your own handwriting and signed by you, it's called holographic. And you don't need extra witnesses when you do it that way. So you would want to date it and sign it, write out like, I'm appointing this person to be the executor and what you want to happen with everything, and then sign it. If it's in someone else's handwriting or typed, that's the third point here on the slide, then that's when you need the two witnesses. So some people get confused because it was in someone else's handwriting. So it has to be your handwriting, your signature, then you're okay. You don't need two witnesses. Anyone else's handwriting or typed, you need to have two witnesses. When you're doing a typed one, there's a couple of different options. One, you see a lawyer, which is the vast majority of people, that's what they do. But there are also online tools to do them. There's a will kit you can get from the Ontario government. And then obviously you can freestyle on your own. So you can type it yourself if you wanted to. I know I'm a little biased saying that you should really consult a lawyer because I am a lawyer, but I only see the problem. So I have, in my 15 years, never seen a will done by someone other than a lawyer. So even the online ones or the government one, or they try and do it themselves, it's done properly. And so the estate ends up paying me more than it would have cost for me to have done the will for the person to fix the mistakes in the will. So that's why I recommend it. You're saving money just by having it done properly. And um, there's a joke they tell lawyers when they first start law school to try and teach us that a lawyer's worst client is themselves. So even like I shouldn't be doing my own will. You need that advice of the other person who's removed from your situation, who's going to talk about things with you and make sure that you've really thought about everything that you're doing and that everything is compliance with the law. And then it's going to be valid, and the probate or the estate administration afterwards will be much simpler for everybody. So there's lots of reasons to do a will. One, you get to direct where your assets go, to who, why, when, all of that. You get to direct who's in charge. So who's the person that's dealing with the estate administration, making all of the decisions and distributing everything. If you have minor children, you can put in there who's going to be the guardian of your child. So if something happens to you before they're 18, someone else needs to take care of them. You get to put that in your will as well. You get to create trusts, like I reviewed. So for minors, for disabled persons, or for others, and makes it a lot easier for them in the management of that and in dealing with the Office of the Children's Lawyer if they're minors, if you have that. With an estate plan and a will, you can usually minimize taxes because, for example, when you come to my office, I have an estate planning questionnaire. So it asks you about all of your assets and everything you have and what you think you want to do. And then we review that before we draft anything. And so I look for assets that could have beneficiary designations so that we can avoid that flowing through the estate and avoid paying the estate administration tax on that. We also look at how you hold things. If you have a spouse, is it just held in your sole name or is it held jointly? And the repercussions of those sorts of things. We look at the land that you own and if there's any ways we can have savings on that as well. And the other great thing about having a will is it minimizes delay and confusion. Because when you have a will, you're naming who's in charge, that person's in charge. They can do things right away. They just need a copy of the will and they can start taking care of things. When there's no will, then which I'll get to, there's a statute that makes decisions on who's in charge. And if that means it's more than one person, you have a little bit of delay while people are sorting things out. And what if they can't work together very well? Or we can't find one of them. So it really helps with that. And it really helps with any confusion because your decision making is taking away from you if you don't have a will. There's a statute that governs what happens, whether you wanted that to happen or not. And it helps people know what you might want because if you put your funeral or burial wishes in there, it makes it really easy for them to implement that. So let's talk a little bit about tax planning. I've alluded to this a little. So with a will, you can tax plan. And lawyers can help you be as tax efficient as possible. And some people, they sometimes joke when they see my will because they're like 20 pages. Are we paying you by page or by letter? And I say back to them, I understand it's funny, but what you're actually paying me for is that first meeting and all that information, going through all of my knowledge, and then coming out at the end with the most efficient plan and that makes sense for you. So it's that process. The will itself is, yes, the end goal, but it's not the pièce de résistance. So going through my brain and talking about what you're doing and making sure we're being as efficient as possible is what you're actually, that's your value. That's why I talk about joint ownership. My last presentation touched on this a bit. If you're spouses and there's no reason in your relationship for anyone to own an asset in their name alone, then it's great to have joint ownership because you'll probably skip having to probate the estate on the first to die. And then beneficiary designation. So registered products, that's like your RSPs, RIFs, LIRAs, LIFs, life insurance, pensions, and your tax-free savings account. Those you can name a beneficiary on all of those. In my wills, I do refer to those beneficiary designations in them because I can be a little more complicated than what you can do with the bank. The bank can handle things like spouse and then my kids, but it can't handle the situation where, say, one of your kids died before you. What I've seen recently is the banks just take the position that that person's name gets removed. So say you had 4 kids and one of them passed away, that account is now being split 3 ways. Whereas usually in your will, you would want that person's share to go to their own children if they had them, but the beneficiary designation doesn't have that kind of complexity at the bank. So we can get into more complex situations with your will and make sure we have everything flowing properly. And then we also have flowing into the trust for a minor so that we protect them from that as well. And so you've heard me talk about probate fees or estate administration tax. I'll explain that quickly for you. So if you have to probate the estate, it's not always that you have to. That's when the estate administration tax is payable. And in Ontario, the first $50,000 of value of the estate is free. There's no tax on that. And then after that, it's 1.5% of the value as of the date of death. There's a couple of deductions you can take off there, but for these purposes, that's just the easy way to do the math. So it's paid at time of application for probate. Probate is the process of taking the original will with its affidavit of execution, a couple of court forms, the death certificate. We serve it on the beneficiaries and we send it to the court. The court then checks through their system to make sure that they don't have a more recent will, that no one's objected to the appointment of the executor or the will. And then they return back what's called the certificate of appointment of estate trustee with a will. So we still call it probate because that phrase is so long. The word probate actually comes from a long time ago, and we used to have a probate court, but we have a unified court now, so it's all one. A lot of people always ask me, well, who decides if we need probate? The asset kind of decides that. So if there's a bank account that has more than $25,000 in it, 99% of the time you're going to have to apply for probate to deal with that bank account. If it's a joint account or beneficiary designation, that doesn't apply. If it's just a regular bank account or investment account, all of the banks don't really go above 25,000. Some of the banks go below that. So there are some banks that it has to be under 10,000 for them to be able to release it with probate. But that's where the decision comes from. So it's not my decision, it's the asset. And then most property, so real estate, needs probate to be able to deal with it. There's a small exception to that that's really complicated, but most of the time you need it for that as well. All right, so now the section of what happens if you die without a will. So in Ontario, the statute is called the Succession Law Reform Act. So all those rumors that are out there in the world that say the government gets all of your money if you die, completely untrue, never been like that. There's a statute for what happens. So what this statute does is it says who has a right to apply to be the executor, and then who are the beneficiaries of the estate. They're not the same list, okay? So if you die without a will and you have a spouse or a common law spouse and children, they're all entitled to apply to be the executor. And so they have to decide between themselves who it's going to be, or if it's going to be everyone, and sign a bunch of paperwork to be able to do that. So that's why I said there can be delay if you don't have a will, because you have that issue of who's in charge. And until you have the who's in charge, you can't do anything. And there's a lot of situations where the spouses or common law spouses and the children aren't all going to get along. And so then you're creating tension and issues for the decision making that needs to happen. So that's who's in charge or who can be in charge. Then you have who gets what. So if you have a spouse and no kids, simple. Spouse gets everything, except common law spouses. So in our Ontario statute, it is the one place where we distinguish between married spouses and common law spouses, and they get different things. So a common law spouse gets nothing. A married spouse gets it all if there's no kids. So if you or your children are in a common law relationship and they're okay with that, then fine. They're most likely not okay with that. And that's why it's very important that people in common law relationships get a will so that people know what's going to happen. If you have a spouse and you have children, then the first $350,000 of the value of the estate goes to the spouse. The rest gets split between the spouse and the children. If you die without a will with no spouse, just kids, then it just gets split between the kids. If you die without a spouse and without kids, then that's where we're going to follow your family tree. So we're going to go up to your parents. If no parents, then to your siblings. If no siblings, down to their kids, so your nieces and nephews, and down from there. If we run out of people going down, then we go back up through your parents and go to what your uncles and aunts would be and flow that way. So it's very much that kin or that family tree that all of us know about. So it follows that once you get outside of the spouse and the kids. And sorry, grandkids would take after kids. So they'd go, if this is you, we're going to go down like this, then we go up like this and out like that. And sometimes that can take a lot of time to figure out because maybe there's some estrangement of kids and we've got to find them. We've got to be able to serve them. And then sometimes they're how we do with common law spouse. So say you were in a 40-year relationship with your common law spouse. You kept all of your assets separate though. So you die, your common law spouse is excluded. They don't get anything. They just have what they have. They have to then sue your estate to be able to get what you most likely wanted to give to them in the first place. And if you have kids, fight with your kids about who gets what. So that's why I say it's very, very important if you're in a common law relationship to look at your estate plan and what your intentions are and what you want to do, because it's unlikely that the law is filling that gap the way you would want. The same can go for married spouses. Most people that I know wouldn't want their spouse to get the first $350,000 and then be forced to split it with kids. They'd want their spouse to get everything and then only go to their kids on the last to die of two people. So there's a lot to look at if you don't have a will. If you do your will, then you're covered, and then you're good to go. All right, I'm at the question part, but I did want to go. Okay, I wanted to talk about a couple extra things if I had a little time. So I'm going to do these, and then I'll open it up for everybody to ask questions. Because these are some questions I get all the time. So when you're appointing an executor, it's my advice that you pick someone based on skill set, not based on any other reason. There used to be a tradition of always naming the firstborn child, but if your firstborn child is bad with money and not good with timelines, they don't have the right skill set to be able to do that. And so you should really think about that. There's a lot of advice out there saying don't name multiple people. It's perfectly fine to have more than one executor named to work jointly with someone. Just make sure they're people that can work together. If you have two sons and they don't even talk to each other anymore, probably not a good idea. But if your family's really close and everyone's great, then it's fine. So it's really just thinking through how that will work and make sure you're not setting them up for failure, for arguments, because that just means the legal fees go through the roof and your kids don't get as much money in the end, which is all that you really want. In the payment of debts, one other question I get from people is, well, what happens if there's not enough money to pay the debts? Do my executors have to pay it? So on the face, the question is no. Your executors are not responsible for your debts. They're only responsible if they do something that makes them responsible. So if your child was a co-signer on your line of credit, they're going to be responsible for that when you die because they're a co-signer on it. If you have a whole bunch of debts and the executor pays one off in full, they can't treat the creditors differently. So if they pay one off in full, they're obligated to pay everybody off in full. So my advice with people when they're not sure how much they have and the debts are high is you have to pay no one until we actually know what you can do, because the creditors are entitled to a pro rata of what the leftover is. So if you have 100,000 in debts and you only have $10,000 at the end of the day, they each get $1,000 instead of each getting 10,000 bucks. And an estate can be bankrupt, just like a person can. So there's ways to deal with that. That's what I wanted to address, which means we can go back to questions. I would just give the people in charge a second to stop recording.